good morning everybody, and welcome to the BBA lecture series 25-26. Members on the dais, members in the audience, it gives us great pleasure to organize this lecture, which I believe is one of the first lectures that the BBA is organizing on this topic. In fact, I was just asking Nitin Bhai whether he remembers us organizing a lecture on this specialized topic, but he also did not remember. So I am grateful to everybody who have contributed in the organization of this lecture. And thank you to the audience for coming here on a Saturday and spending time. Before we go ahead, I'd like to call upon our President, Mr. Thakkar, to address the audience and say a few words. Mr. Thakkar.
Thank you, Farhan. Good morning, everyone. I will take only 2 minutes. First of all, very warm welcome to all of you. I am extremely grateful to Justice Jitendra Jain for having agreed to come here and today preside over this function. Thank you very much, sir. I am equally grateful to Justice Srikrishna for having initiated the thought of having this lecture by Bombay Bar Association. Farhan is right, Bombay Bar Association has not done any other seminar prior to this on tax laws. We have been doing seminars on various subjects in our series of continuous education for bar members. This is the first time we are doing something on tax laws, and Justice Sri Krishna, we are extremely grateful to you for having initiated this, inspired us to do this, and having kindly agreed to come and deliver one of the lectures out of this. And Dhruv, Dr. Dhruv is a person who is well known in this tax field. It is he who probably worked with Justice Sri Krishna, and I believe Justice Sri Krishna was impressed by his work, and all of us will know his knowledge and he is going to share with us. Thank you very much, Dhruv, for having done that. And my special thanks to a very reverential person who is sitting in front of us, Soli Dastur. Sir, thank you very much for coming here for this, and we are very, very thankful to you for having graced this occasion. So there are quite, you see there are less number of people, but be rest assured, this lecture is being recorded and will be on YouTube channel of Bombay Bar Association. So it is there to stay for all times to come. Thank you very much. May I now request Farhan Dubash to present.
Thank you. Thank you, Nitin Bhai. We'd like to present a small token of our appreciation to Justice Jitendra Jain. May I request our President Nitin Bhai to present this to Justice Jain. I'd like to call upon our committee member, Ms. Neha Feni, to present it to Justice Sri Krishna. And Kainaz, I'd like to call upon our other committee member, Kainaz, to present it to Dr. Dhruv Sanghavi. In addition to the plant that of course everybody can see, we have our legacy book and the special edition of the Bombay Bar Association bottle that we had made, that we've given to all the 3 speakers on the dais. We hope it's of use to everybody. Seeing Mr. Dastur here in the audience, only only reinforces the saying that when you are a lawyer, you learn till the last day. And his presence in this lecture, I believe, truly embodies that. Thank you, sir, for being present. Now, to start today's function, I'd like to call upon my colleague Naushad Engineer to address the audience. Naushad.
Justice Jain, Justice Srikrishna, Mr. Thakkar, Mr. Dubash, Mr. Dastur, ladies and gentlemen. It's my privilege to start today's lecture series by introducing the speakers on the panel. Of course, Justice Jitendra Jain is anyone who has been practicing in the Bombay High Court, he really needs no introduction. But since there are so many younger members as well, and I believe some chartered accountants, etc., who are in the audience, let me just say that Justice Jain, he completed his schooling in Mumbai and went on to earn a Bachelor of Commerce from Jai Hind College and a law degree then from the prestigious Government Law College at Mumbai. In addition to studying law, he is also a qualified chartered accountant, cost accountant, and has also completed his course as a company secretary. After attaining these qualifications, Justice Jain commenced his counsel practice in the year 1997, working in the distinguished chambers of the legendary Mr. Rafiq Dada. Over the years, Justice Jain has built a stellar reputation in the fields of direct and indirect taxation, fiscal, economic, corporate, as well as constitutional laws. He has regularly appeared before the Supreme Court of India, the Bombay High Court, and various other high courts in the country. He has also represented clients before the direct and indirect tax tribunals in Mumbai, Chennai, Hyderabad, Pune, and Goa. Beyond his legal practice, Justice Jain has contributed significantly to legal education. He has taught taxation laws to aspiring chartered and cost accountants and authored many insightful articles and research papers, and has in fact even written a book on the Maharashtra Protection of Interest of Depositors Act. His commitment to simplifying complex financial, fiscal, and economic laws has benefited professionals, students, and wider public alike. After having a very successful career as a counsel, which has spanned over 2 decades, he chose to serve a higher calling by accepting judgeship. He was elevated as a judge of the Bombay High Court on 15th June 2023. We are indeed honored and grateful to Justice Jain for having taken time out from what is otherwise extremely busy and demanding schedule to come here and give us his presidential address. In addition to Justice Jain, we have with us on the dais a man who really needs no introduction, and that is Justice B.N. Srikrishna. Anyone who has lived in Bombay is synonymous with the name Srikrishna. Justice Srikrishna, however, was born in Bangalore on 21st of May 1941. He was brought up in Bombay, now Mumbai, and graduated with a bachelor's degree in science from the Elphinstone College of the University of Bombay. He received a Bachelor of Laws also from Government Law College and a Master of Laws from the University of Mumbai, in which he stood second in the university. He holds, in addition to law, a Master of Arts degree in Sanskrit from the University of Mysore and a diploma in Urdu and a postgraduate diploma in Indian aesthetics from the University of Bombay. On 23rd of December 1962, he was enrolled as an advocate, and Justice Srikrishna entered private practice and practiced predominantly in labor and service fields, in which he went on to excel. He was the counsel of choice for most corporations and was also a distinguished and designated senior advocate. He has appeared in so many matters. Of course, one of the most notable ones was where he had appeared for the Millers Association in the famous Datta Savant mill strike. On 30th of July 1990, Justice Srikrishna was elevated as a judge of the Bombay High Court when the Bombay High Court really, there was a crisis at that point of time, when 7 judges basically were not being provided with work, and the then Chief Justice requested him to come and actually take up judgeship to try and resolve the situation. And he, despite having one of the most successful labor practices at that point of time, he agreed and sacrificed in that sense for himself, but ultimately served a greater and higher calling. In 1993, as we all know, after the Bombay riots took place, the confidence which was shown in Justice Srikrishna as he then took up the commission to deliver his famous report, which we are all aware of. In 2001, he was then elevated as the Chief Justice of the Kerala High Court, and on 3rd of October 2002, he was elevated to the Supreme Court of India, at which he retired in May of 2006. Post-retirement, he has been an arbitrator of choice, as well as delivering various other lectures and speaking at various forums. And we're indeed grateful to Justice Srikrishna for gracing us today as well and giving his talk on tax laws. And our other distinguished speaker today is Dr. Dhruv Sanghavi. Dhruv is an advocate who specializes in international tax laws. He argues tax treaty cases before courts and tribunals across India. Dhruv started his career in Bombay with Nishit Desai Associates in 2007 and also worked with Mr. Ajay Vora, a senior advocate in New Delhi, for a few years. He then traveled on an academic path to the Netherlands, obtained his advanced LLM from Leiden University and his doctorate from Maastricht University. He contributes regularly to the work of the United Nations Committee of International Tax Experts and the OECD. He has now shifted his fixed base as a tax counsel to Bombay. Besides the ITAT and the Bombay High Court, Dhruv has most recently appeared before the Delhi High Court in the case of Tiger Global and the Karnataka High Court in the case of Mobicon Technologies. In today's lecture, Dhruv will be taking a close look at fundamental aspects of tax treaties and will review critically a few landmark cases in this process. I'm sure we will all greatly benefit from hearing today's speakers. Thank you. May I ask Justice Jain to last? Very well. So then, Justice Srikrishna, if you would please come and deliver your address.
Justice Jain, or should I say Brother Jain, Nitin Bhai, Farhan, Naushad, and of course Dhruv, and all the friends here. Pardon me for addressing all of them by first name, because somehow I feel funny if I have to call them Mr., Doctor, Justice and all that. Yeah, you know, I standing here, there is a sense of deja vu in two senses. That after a long time I'm entering these premises because these people pushed me out in 1990 and said, we don't want you here, get out. Not that the judiciary wanted me, they pushed me out of here. Now, second, after a long time, it's very strange to see Soli Dastur sitting in the first row and I'm waiting for him to get up and argue the matter. Yes, Mr. Dastur, what is your question? It used to be very enjoyable. I used to sit in the tax bench in the central court, where he would be one of the fixtures in the front row. And we used to enjoy his arguments, you know, putting things in proper perspective, making it understandable even to a dunce like me. Well, if I learned what is tax law, I must really congratulate, and also I am grateful to all the big-time lawyers. Of course, I didn't have the fortune of having Palkiwala before me. Palkiwala came to me, but in a different matter, on a different issue, not on tax issue. But it was really a pleasure and an opportunity to learn. Okay, I'm talking. Okay. He is asking me to step back. Very well. At this age, what else can I do? Can somebody give me some water, please? My throat is thin. So it was a pleasure listening to all the big guns in the tax jurisdiction, and I learned a lot in the bargain. I remember my first assignment was with Justice Bharucha in this room. What is that room number? I forgot. The next room? 40. And I was sitting with him, and one of the matters was on excise law. I had never done any tax law in my practice. I had concentrated only on labor matters, and I thought I was fairly up with that. So when this matter was argued, Justice Bharucha turns to me and says, "Brother, the tradition in the Bombay High Court is that as soon as the arguments are over, the judge starts writing the judgment, dictating the judgment, and we do it alternately. I have already finished mine, it's your turn now." I said, "Sam, but I don't know anything about excise law." He said, "Oh, you're not familiar? Very good, we'll keep it tomorrow. You study it and come back and dictate the judgment tomorrow." So ladies and gentlemen, that was my first lesson in learning tax law, and that too excise law. Well, it's like, teaching a child, I don't know how to swim, pick the child and put it in the pool. It has to swim to save its life, and that is how I saved my life, by trying to understand what the rudiments of taxation law are. I never, after leaving Bombay High Court, perhaps in the Kerala High Court I did 1 or 2 matters. In the Supreme Court was another teaching for me. I was put on the criminal bench all the time, and it was a pleasant surprise that I was made to sit on a bench which took up tax matters, and fortunately I happened to be at the right time, at the right place, and that is how Azadi Andolan Bachao Andolan got into, written by me. Anyway, this is the story of my life. Learn always, and continue learning till it is not a passada. I'm not used to speaking to mics. A, I'm not used to speaking in front of mics. B, I am not used to giving long lectures, because long lectures are good for lawyers because it earns them fees, good for politicians because it gets them votes. I am neither. Okay, now let's get back to, I don't know why I have been asked to come and talk here, because the talk is to be done by Dhruv. The presiding judge is the Justice Jain, who are experts in tax laws, and I am the odd man out, and I have been asked to speak about international taxation. Very well. There are some of the interesting problems that have arisen in international taxation. And why have the problems arisen? Go back to the basics. Tax is a sovereign's prerogative. Every country has a sovereign, and the sovereign is only has the right to tax. Now, in the good old days, every Raja gave a decree and collected tax, rightly or wrongly, whether it is Aurangzeb or somebody else. But what happens in the next country? The next country says, I am also sovereign, I have the right to tax my suit. But fine, as long as each state or each country was treated as a separate unit, there was no problem at all. But today, we are talking in terms of Vasudhaiva Kutumbakam, globalization of the entire world, where there is going to be constant international commercial transactions between states and states. People are moving. Even if the plane crashes also, we continue to move. Now we move from here to another, do business, come back, earn some money in this country, go to another country, set up a corporation, things like that. Or set up a profession and make money. Now in such cases, the questions arise as to who is the authority to collect tax from in such a situation. This has given rise to a separate jurisdiction called international tax jurisdiction. Because in international tax jurisdiction, it is not the Supreme Court of India or the Supreme Court of the UK will be, or the Supreme Court of US which will have the last word. Even if they have the last word, they have to follow the acceptable international principles in order to do justice to their own citizens or to citizens and residents of other countries who are before them. Now, what problems do you encounter? The problems are like double taxation. Now, take for example my friend Dhruv. He earns money in Holland, he earns money in Bombay, in India. Now, is it to be taxed in India, or is it to be taxed in Holland, or is it to be taxed at both places? Is there any methodology? Now, this is the problem that has been solved by entering into what is known as avoidance of double taxation treaties. So, the Holland and India will say, hey, if my citizen comes to your country and earns a tax, and he is also liable to tax here, we will adjust it in some manner. We will either give him a rebate, or we will ultimately say that he is not liable to be taxed at both ends, or we will be taxed at lower levels in respect of different types of heads of income. Now, this is what is known as juridical double taxation. Then we have economic double taxation. This same income is taxed in the hands of different persons, corporate profits being taxed at the company level, and then again when distributed to shareholders at dividend. Double taxation significantly increases the overall tax burden, reduces profitability for businesses, and can discourage cross-border investment on the whole. This is why you had double tax avoidance treaties, one of which was the Indo-Mauritius treaties, which I had the good or the bad fortune to decide about. Now, there is also a concept of tax avoidance and tax evasion. A famous judge in England said, there are two things only certain in life, death and tax. Tax I have paid all my life, and I am waiting for the other event to happen shortly. So, you cannot avoid death, but certainly you can avoid tax. If you avoid tax, you have a problem. In what manner are you avoiding it? Are you going to cheat? Then you will go to jail. If you arrange your affairs in such a manner that there is the least incidence of least taxation on you, you are okay, you are allowed to do that, and that is called avoidance, whereas trying to cheat, trying to take cash and get away with it, trying to forge vouchers, trying to make double accounts as they used to call it, that is not permissible in law. Then there is also this concept of treaty shopping. As I told you, two countries enter into a treaty by which the resident of one country and the resident of another country are not doubly taxed at each other's place. When this happens, smart guys say, hey, Mauritius is a country where there is no taxation on certain aspects, or where is the least taxation on certain aspects. So let me pretend to be a resident of Mauritius and take advantage of the India-Mauritius double taxation avoidance treaty. Now that is called treaty shopping. What do you do? I mean, all lawyers are familiar with judge shopping, no court shopping. What do? You have a bad judge like me sitting in a court, you will make sure kaisa bhi karke objection nikalo, so the matter will be removed. Or there will be somebody who will say that so and so Mr. appearing here is your relative, so I will say remove it from my judge. And you will make sure that the matter will go only to a good judge like Justice Jain. That is called judge shopping. Treaty shopping is something like that. You do it, arrange your affairs in such a manner that you, for all the purposes, you feel that you are a person entitled to take advantage of the softer tax laws in a jurisdiction and pass off the person covered by that jurisdiction. That is the double taxation avoidance treaty. And of course, the judgment which Dhruv referred to had much more complications in that. It is not so simple. But this is basically what happens in a double taxation avoidance treaty, and smart lawyers trying to avoid that by doing this treaty shopping. Then one of the questions that arises is, what is wrong with treaty shopping? Is treaty shopping immoral? No, certainly not. Bhagavad Gita didn't tell me that treaty shopping is wrong. Ramayana doesn't tell me that, nor does the Bible. Then why are people afraid of it? Why are people criticizing it? People are criticizing it because that way the taxation levels goes down on persons who ought to have morally paid more tax. In that sense, it is morally probably unjustified, but legally it is justified unless there is a law which says you shall not do this A, B, C, D. That was the crux of the issue in the Azadi Bachao Andolan case. That as long as Parliament has not decided that treaty shopping is wrong legally, you certainly are entitled to arrange your affairs in such a manner that you can pass off yourself as legally qualified to be a resident of a particular country where you get the least taxation incidence on you. That is talking of treaty shopping. Then we have the biggest threat that is going to be, in fact, I'm happy that the Bombay Bar Association decided to have this kind of seminar or lecture series, because I also notice that they do a lot of good work. They hold lectures on civil procedure code, criminal procedure code, and the usual thing that we are taught in the courts. But this is a subject that is going to trouble every young lawyer today. Now, how do you decide with a situation where there is digital taxation? In a digital sense, where is the locus? Otherwise, one of the fundamental things is taxation incident falls either because of residence or because of your locus, in the sense you have a business. Now, in a digital economy, where is the locus? There is no locus. So how do you identify where do the tax incidents occur? This is going to be another problem which lawyers have grappled with, international agreements and treaties are grappling with, and it is going to be more and more complicated in our country because our country is now on the takeoff for digital economy. Now, what are the different manner in which solutions have been attempted? The OECD, that is the Organization of Economic Cooperation, what is it? Cooperation and? Cooperation and Development. There is an international association, organization known as OECD, which deals with how the taxation matters at international level should be organized. They are something like, the 10 wise guys who sit there and say, and they're composed of various interests of all over the world. And they say that, hey, look, if we have to carry on international commercial transactions in a sensible manner, in a just manner, these are the ground rules which must be followed. Now, and when how a treaty is to be interpreted, how treaties are to be entered into, these are all complicated issues which are settled by people who are experts there. Now, they have come out with what is known as two-pillar solution. Now, two-pillar solution is what? It is a major international effort to address this issue of treaty shopping. Oh, shucks. I know, my phone was seized by a judge of the Supreme Court when I was sitting next to her, and my phone. See, that shows that judges in this country follow the law. The pillar one solution. Pillar one is, it aims to reallocate a portion of the largest and most profitable multinational enterprises' profit to market jurisdictions regardless of physical presence. That is one methodology of solving it. The other is pillar two solution. It aims to ensure that large multinational corporations pay a minimum effective tax rate, currently 15%, I think, on their profits, regardless of where they are operating. That is the second solution that the OECD has formulated and is advocating. Now, why is it that there is complexity and diversity of tax regulations? Every country, as I told you, has its own unique tax laws, rates, and compliance requirements. The diversity makes it extremely challenging for businesses operating across borders to navigate the tax landscape and ensure compliance. Now, in this country, we are quite used to diversity because the chap in Kerala will not know what is Punjabi and the chap in Punjabi will not know what is Marathi. But we are carrying on, aren't we? Now, if we are carrying on at the elementary level of language, At tax level also you should be able to do it as long as the tax laws are written in a language that is understandable to every citizen in his own fashion. Frequent changes. Tax policies are subject to very frequent changes. They have to be updated. Of course, yes, because what is tax after all? Tax is the money that is required by a government to run itself. And our governments are notorious for increasing their budgets because they want to keep on increasing. For what can be done by 1%, they want 50%. So there is bound to be inflation in the budget itself. Inflation requires money to be collected, and money to be collected means there are limited sources. We don't produce enough. Then what do? Tax. There will be GST tax on bread without butter, GST tax on bread with butter, bread and butter and sugar will have third tax. So you will have 9% plus 9%. I don't know, now they are decreasing it from 18%. So as it is for everything. Now, some brilliant finance minister may say, you are all breathing in this country. No, for every breath of air that you take, there shall be 9% GST and 9% CGST. It's possible, because that is exactly how governments survive. Now, because of this happens, our neighbor will say, "Are you are having 18%? Well, I'll make it 20." Now, please see what is happening, the tariff quarrel between the famous president in America and the subsident in China. So he says, "I will charge 100% tariff," he'll say 125% tariff. You 125%, I'll pay 130%. This kind of keeping up goes on between sovereigns all the time, and that is going to hurt the people at the lower level. That is why you need to have common ground on which people operate. Otherwise, it's territory which will become uncharted. Now, what happens in this taxation competition? There is what is the principal note as the race to the bottom, the doctrine of race to the bottom in this tax competition. Countries may engage in tax competition by lowering their corporate tax and rates or offering effective incentive to attract foreign investment, which we have done quite often. While this can stimulate economic activity, it can also lead to a race to the bottom where tax rates are continuously driven down, sending the tax base for all the countries and shifting the tax burden to other sources like individuals. Now, there are also administrative and enforcement challenges. Tax is a matter of collection, and at least in India, we are experts in dodging tax in known methods and unknown methods also. Resource constraints. Tax authorities in many countries, especially developing ones, may lack the resources, expertise, and technological advances to effectively administer and enforce complex international tax laws. This is the reason why I said it's necessary that our youngsters should understand what the problems are. They should be geared up to meet what is going to happen tomorrow, maybe 5 years down the line, 10 years down the line. Now, we were studying elementary things like injunction suit and title suit and things, and like those days are gone. We are here in an advanced digital economy, and this is one of the issues that needs to be understood and internalized every day. Then there is also the information asymmetry. It's difficult for tax authorities to obtain complete and accurate information about cross-border transactions and the global operations of multinational corporations. Dispute resolutions between tax authorities of different countries over tax matters can be lengthy and costly. Now, what are the concerns of a developing economy or a half-developing economy like ours? Developing countries often feel disproportionately affected by international tax problems, as they may lack the resources to effectively combat tax avoidance and profit sharing, leading to significant revenue losses that could be used for development. Addressing these problems requires ongoing international cooperation, the development of common standards and effective enforcement mechanisms to ensure a fair and sustainable international tax system. It also requires the youngsters to study the tax systems that are developing in the country and be geared to meet the future litigation in these areas tomorrow. Thank you, and I don't think I'm qualified to talk about tax administration, international tax laws. You have a better person. You have better persons actually. You have Dhruv who has got a doctorate in the subject, and of course you have a sitting judge of the Bombay High Court who will be able to talk to you about this. Thank you very much for listening to me patiently. God bless you all.
Can I now request Dr. Dhruv Sanghavi to deliver his speech to the audience? Dhruv.
Honorable Justice Jain, Honorable Justice Dr. Srikrishna, Mr. President Thakkar, Mr. Secretary Dubash, Mr. Engineer, esteemed seniors and members of the Bar Association, and dear friends, I'm grateful today for your invitation to share my critical appreciation of international tax law in India. It is truly an honor for me to be delivering this lecture here, as it was here at the Bombay High Court that my now 18-year love affair with international tax began, when Mr. Chagla was arguing the Vodafone case before Justice Radhakrishnan and Justice Nirgude back in 2008. The subject before us is not only vast, but is also rather technical. And I recognize that the audience today might be a healthy mix of specialists and those who are here out of sheer curiosity. There might also be some people I might have bribed with a lunch afterwards, who are over here to fill up perhaps the numbers. Therefore, I shall endeavor to make today's subject both approachable and pithy to engage everyone. To this end, I have divided this lecture in two parts. First, I shall deal with certain building blocks of international tax law. The second part could be called black and white or gray, in which I will deal with some cases and determine whether international tax law is really a black and white decision, or are there issues that our current state of international tax law interpretation in India lies in an area of gray despite a number of case law. So, to the building blocks. The expression international tax is really a misnomer. There is no international tax body imposing a supranational tax on international income. The term refers merely to national taxes applied to cross-border flows of income and capital. Whilst countries are free within their constitutional limits to impose taxes on any income, on any person as they wish to, the unrestricted imposition of such taxes under domestic law would result in overlapping tax claims between two or more countries. This phenomenon is referred to as juridical double taxation. To quote the OECD, and I quote, "Its harmful effects on the exchange of goods and services and movements of capital, technology, and persons are so well known that it is scarcely necessary to stress the importance of removing the obstacles that double taxation presents to the development of economic relations between countries," unquote. Although such double taxation could in theory be relieved unilaterally by the country of which the taxpayer is a resident, this is hardly the case in practice. One of the other issues with unilateral relief is that the burden of relieving double taxation falls solely on one country. This is where bilateral tax treaties, which are instruments of international law concerning direct taxation, come into the picture. These treaties form the bedrock of the international law on taxation, or put simply, international tax law. Bilateral tax treaties, which have been in a state of gradual but constant evolution for 160 years, are designed in a manner that both contracting states share the burden of resolving double taxation. Modern double tax treaties are based fundamentally on what is colloquially referred to as the distribution of taxing rights between contracting states, on notions of economic allegiance or territorial nexus. As a side note, by the way, these norms of economic allegiance and territorial nexus were developed a long time ago in the 1920s by the League of Nations. There is widespread consensus in the world that change is necessary. And not for want of effort, by the way, but there is no consensus yet on what this change should be. But I digress. This lecture is not about what the law ought to be, but rather what the law is currently and how it should be interpreted and implemented. So, how do tax treaties interact with the Indian Income Tax Act of 1961? That is the fundamental question I seek to address in the first part of this lecture. As you all know, treaty-making power vests exclusively with the executive under Article 73(1) of the Indian Constitution. Article 253 empowers Parliament with the authority to implement these treaties. Usually, this translates in the executive negotiating and executing a tax treaty and Parliament ratifying and implementing the treaty. However, tax treaties are different. Section 90, subsection 1 of the Income Tax Act delegates the authority to conclude tax treaties to the central government. Subsection 2, on the other hand, sort of pre-ratifies the implementation of such tax treaties by stating that the provisions of the Act shall apply to an assessee to whom a treaty applies only insofar as they, that is the provisions of the Act, are more beneficial to her, or him, or it. The obvious question arises, in what way can the provisions of the Act be more beneficial than the provisions of a treaty, or vice versa? Two things must do the same thing for them to be comparable, and for one to be more beneficial than the other. But do the Income Tax Act and tax treaties perform the same functions for them to be comparable? The decision of the Special Bench of the Income Tax Appellate Tribunal in Motorola versus DCIT 147 Taxman 3039 is cited often to suggest that tax treaties provide an alternative tax regime to the Income Tax Act. A similar sentiment was expressed by the Andhra Pradesh High Court in Sanofi Pasteur 354 ITR 316. The notion of an alternative tax regime may conjure up images of a tax code replete with provisions dealing with the computation of income, the attribution of income to a taxpayer, the creation of a charge to tax at prescribed rates, exemption provisions, etc. However, tax treaties do none of this. Despite the colloquial aphorism that tax treaties allocate taxing rights, a closer examination of its provisions will reveal that it only sets limits to a country's sovereignty in taxing whatever income it wishes to. Klaus Vogel refers to the tax treaties as a stencil casting a shadow on a blank sheet of paper, which is the domestic tax claims. Only those domestic tax claims on which the stencil does not cast a shadow may be implemented by a country. The starting point of any tax treaty analysis, therefore, must be the domestic law of a country. The Income Tax Act of 1961 in India's case. Only after these domestic tax claims have been computed fully can one determine the extent to which a tax treaty restricts them. This process may seem superfluous and unnecessarily tedious to a tax advisor in a hurry who might much rather prefer to have a beer after work. But this approach is not problematic only in cases where tax treaties restrict India's tax claims completely. However, there may be instances in which the hasty approach may yield outcomes that are not only incorrect, but also rather expensive, either to the government or to the taxpayer. Such a potential situation arose in the recent case of Hyosung Corporation decided by the Income Tax Appellate Tribunal. Here are the facts, and I must apologize to the audience that the PowerPoint presentation cannot be put up, so you'll have to bear with me. But I'll try and summarize the facts, which are slightly altered for the sake of easy comprehension. In this case, the company was a resident of Korea, and it earns fees for technical services of 80 arising in India. These fees for technical services are not attributable to the taxpayer's permanent establishment in India. Brought forward losses of 50, however, are attributable to its permanent establishment in India. Under the Income Tax Act, both streams of income, the fees for technical services and the negative income being the brought forward losses, fall within the head profits and gains from business or profession. Under the domestic law, therefore, 80 minus 50, that is only 30, may be taxed and subjected to a withholding tax of 20%. This equates to a tax liability of 6 on the taxpayer, that is 20% of 30. Now let us look at the tax treaty. Article 12 of the Korea-India Tax Treaty states that fees for technical services derived by a resident of Korea may be taxed in Korea. Paragraph 2 thereafter says, however, such fees for technical services may also be taxed in India and in accordance with the laws of India, but if the beneficial owner of the fees for technical services is a resident of Korea, then the tax, please bear in mind, the tax so charged shall not exceed 10% of the gross amount of fees for technical services. It is often said that tax treaties create a charge by prescribing a withholding tax rate on certain items of income, like fees for technical services in this case. However, a closer look at Article 12.2 reveals that it prescribes neither the amount of income which is taxable, nor the rate of tax applicable, but it merely limits the amount of tax that may be levied by India on the fees for technical services. In the facts that I've just presented to you, that limit would be represented by 10% on the 80 of fees for gross amount of fees for technical services, and so the limit is 8. Even though the domestic withholding tax rate of 20% was greater than the 10% stated in the treaty, the final tax bill under domestic law of 6 is well within the limit of 8 set by the treaty, and therefore it is not restricted by the treaty. Not for a moment am I suggesting that the term more beneficial used in the Income Tax Act is meaningless, but it may be partly superfluous. The correct way, in my opinion, to interpret Section 90, subsection 2, therefore, is the provisions of this Act shall apply to a taxpayer only to the extent they are not restricted by a tax treaty. Another intuitively appealing but inaccurate, in my submission, idea is that the definition of a term in a tax treaty may be more beneficial than the definition of the domestic law meaning of that term. This idea appears to have received judicial approval in an obiter dictum of the celebrated Supreme Court case of engineering analysis, 432 ITR 471. At paragraph 100, Justice Nariman stated, and I quote, "Any ruling on the more expansive language contained in the explanations to Section 916 of the Income Tax Act would have to be ignored if it is wider and less beneficial to the assessee than the definition contained in the DTAA as per Section 90, subsection 2 of the Income Tax Act." Unquote. With due respect, the fallacy of this obiter dictum becomes apparent once we read the treaty definition of royalties. The definition in Article 12.3 of the US-India Tax Treaty, as with every other treaty India has concluded, begins with the expression, "The term royalties as used in this article means. Now let's look at the domestic definition of the term royalty, which is defined in explanation 2 to section 916. It states, for the purposes of this clause, royalty means, even though the terms royalty and royalties used in domestic law and treaties respectively are similar, they may mean one thing for the purposes of the Income Tax Act and quite another or another thing entirely for treaty purposes, which then restricts your domestic law. So first you apply your domestic law definitions for the purposes of domestic law, determine what your domestic tax liability is, then apply the treaty definitions to the treaty and see how far the domestic law is restricted by the treaty. That is not to say that there can be no interaction whatsoever between the terms of a treaty on the one hand and domestic law meanings at all. According to Article 3, Paragraph 2, a term used but not defined in a treaty, unless the context otherwise requires, has the meaning it has under the domestic law of the state applying the tax treaty at the time of the application of the treaty. Given that reference to domestic law is dynamic, countries can and often tend to become creative when changing their domestic law definitions so as to gain more taxing rights than was contemplated in the treaty. India has been one such creative country. Now, most tax treaties define the term royalties to include payment for the use or the right to use a secret formula or process. Although the term secret formula or process is part of a definition, it is not itself defined. Under the rule of Article 3.2, the undefined term must derive its meaning from the domestic law, unless, of course, the context requires otherwise. The international consensus, as reflected in the OECD commentaries, is clear. The adjective secret qualifies both formula and process. Therefore, the payments for the use of a process which is not a secret process may not be characterized as royalties. Let me contextualize this by using a hypothetical. Consider a company which is a resident of the Netherlands, which allows an Indian broadcasting company to use the transponder capacity on its satellites. The consideration payable for the use of this capacity may be characterized as payments for the use of a process. Now, most people who paid attention to their physics classes in high school would know the process of reflection of radio waves through a satellite, as is used in satellite communication. The engineering may be complex, but the process is not a secret. Can the consideration paid by the Indian company to the Dutch company be characterized as royalties? This issue has been quite controversial in Indian case law. On the one hand, the Delhi High Court in New Sky Satellite 382 ITR 114 was in consonance with the international consensus. The process ought to be a secret process. The Madras High Court, on the other hand, in Verizon Communications Singapore 361 ITR 575, concluded otherwise. The issue is now pending before the Supreme Court. India, in the meantime, has been creative by inserting a retrospective explanation which states that the term secret applies only to formula and not a process, and states expressly that payments for the use of satellite transponder capacity is characterized as a royalty. Reading Article 3, Paragraph 2 strictly, the treaty meaning would follow the domestic meaning unless the context otherwise requires. This is especially problematic because 3.2, as I already mentioned, refers to domestic law dynamically and not the domestic law as it was at the time when the treaty was concluded. The question, therefore, is, can India alter the allocation of taxing rights unilaterally by altering domestic law, the domestic law meaning of an undefined treaty term? Or does the context require otherwise? And how do we determine what the context is? There are many ways of determining context. One is particularly useful in the instant controversy of transponder capacities. The Netherlands-India Tax Treaty is concluded not only in English, but also in Hindi and in Dutch. Each of these versions is equally authentic. Let us see if the Hindi or the Dutch versions of the treaty are useful in providing context. The Hindi version uses the term Gupt Formulaya Prakriya, which is not particularly helpful in this regard, because whether the adjective Gupt applies to only formula or also to Prakriya is equally relevant in Hindi. The Dutch text, however, uses the expression een geheim recept of een geheime werkwijze, which translates to a secret formula or a secret process. The text reflects the clear intention of the contracting states that only payments for a secret process should be characterized as royalties. Now, I would be intellectually dishonest if I did not point out that the concluding part of the Netherlands-India Tax Treaty states that whilst all language versions are equally authentic, in case of a divergence between the Dutch and the Hindi texts, the English text shall be operative. But does such a divergence exist between the Dutch and the Hindi texts? Should a divergence be said to exist at the slightest difference in wording, or should a reconciliation be made wherever it is possible to discover a common meaning? I submit the latter for the following reasons. First, the English and the Hindi usages of secret formula or process, or Gupt Formulaya Prakriya, can be ordinarily interpreted to mean secret formula and secret processes. These are not antithetical. Secondly, the double use of the term secret in the Dutch text is a consequence not of Dutch creativity, but of Dutch grammar. Nouns in Dutch are either gendered or they are non-gendered. Non-gendered nouns are preceded by the definite article het, whereas gendered nouns are preceded by the definite article de. Adjectives qualifying non-gendered or the het nouns do not carry an E at the end of them, whereas gendered nouns are qualified by adjectives which are appended with an E. The Dutch noun recept, that is formula, is a non-gendered noun and must be qualified by the adjective geheim, whereas the noun werkwijze is feminine and must be qualified by the adjective geheime. Given these linguistic requirements, the Dutch text of the treaty could not have been drafted differently. As long as such language does not contradict the Hindi or the English versions, no divergence should be construed as to ignore the clear Dutch language in favor of the artificially ambiguous Hindi or English texts. Thirdly, India's tax treaty with the Netherlands is not an exception. The Dutch version of India's tax treaty with Belgium uses exactly the same terminology. Fourthly, Dutch is not the only non-English and non-Hindi text which gives us this meaning. The French adjective secret in secret d'une formule ou d'un procédé, and the German adjective geheimen in geheimen Formellen oder Verfahren are plural. That means the plural adjective qualifies both the nouns. Every single Indian tax treaty which is concluded with a Francophone country or a German-speaking country has the same expression. The same is true also for the French version of the OECD model. This, to my mind, proves beyond doubt that the treaty context requires that the term secret formula or process should be interpreted to mean a secret formula or a secret process. Therefore, payments for the use of non-secret processes like that of a satellite transponder cannot be characterized as royalties for treaty purposes, despite the reference to domestic law under Article 3.2. Unfortunately, This aspect of tax treaties being concluded in different languages has never been examined by courts in India, perhaps because the argument was never placed before it. One does hope that the exercise of treaty interpretation by courts in India evolves to adopt a holistic approach of evidence-based interpretation as opposed to rhetorical interpretation. We have now reached the midpoint of this lecture, and we may profit by restating the two building blocks we've discussed so far. First, tax treaties operate by restricting domestic law and do not create a charge to tax by themselves. Secondly, same or similar terms used in domestic law and tax treaties may have different meanings and should not be assumed to mean the same thing. They operate at different planes and may have different meanings within those planes. Let us now come to part 2, which is titled Black, White and Grey. The first case I shall examine critically is the Andhra Pradesh High Court decision in Sanofi Pasteur, which I have already referred to earlier. In this case, a company which was a resident of France earned capital gains from the sale of shares in another company which was also a resident of France. Those shares, however, derived their value substantially from shares of a company which was a resident of India. In simple terms, the transferor earned capital gains from the indirect transfer of the shares of an Indian company. Capital gains earned by a non-resident are taxable in India if they are derived directly or indirectly from the transfer of a capital asset situated in India. Explanation 5 to Section 911 of the Income Tax Act was inserted retrospectively to state that shares of a foreign company which derived their value substantially from assets located in India are deemed to be situated in India. The law does not pierce the corporate veil. They simply deem the situs of the shares of the foreign company to be in India. The question then arises is whether the France-India tax treaty restricted India's domestic tax claims for taxing these capital gains. I will read out for you Article 14.5 of the France-India tax treaty, which is the relevant distributive rule in this scenario. Gains from the alienation of shares other than those mentioned in paragraph 4, representing a participation of at least 10% in a company which is a resident of a contracting state, may be taxed in that state. Let us read this same language by replacing the term contracting state by the name of the relevant country. Assuming that the 10% threshold has been satisfied and the shares do not fall within the scope of paragraph 4, the provision would read as under. Gains from the alienation of shares in a company which is a resident of France may be taxed in France. The question we must ask, if you remember the first building block, is does paragraph 4 restrict India from taxing these capital gains? The answer is no. Interpreting solely Article 14, paragraph 4, nothing restricts India from taxing these gains. It simply says the gains may be taxed in France. The Andhra Pradesh High Court, however, concluded that Article 14.5 in clear and unambiguous and explicit terms allocates the resultant capital gains to France. Respectfully, the High Court committed the error in asking whether the treaty allocated taxing rights instead of adhering to the first building block and asking whether the France-India treaty restricted India from taxing the capital gains. Some may argue that the term may be taxed, as used in Article 14.4, should be interpreted to mean shall be taxable only in France. To them, I shall point out to Article 14.6 of the France-India Treaty, which states gains from the alienation of property other than that mentioned in the preceding paragraphs shall be taxable only in the contracting state in which the alienator is a resident. The distributive rule, like many across the tax treaty and all tax treaties in reality, employs the expression shall be taxable only when it was so intended. Some, as did the Andhra Pradesh High Court, would recite Justice Srikrishna's citation of Francis Benyon in Azadi Bachao Andolan. Benyon said famously that, quote, "The drafting of treaties is notoriously sloppy, usually for very good reason," unquote. This citation was not so much as part of the ratio decidendi, in my humble opinion, in Azadi Bachao Andolan. And it appears to have been accepted as gospel truth by courts across the country. A preliminary search that one of my juniors did on Taxman, looking for the terms Benyon and sloppy, pulled out 180 international tax cases in which this has been cited to indeed interpret tax treaties liberally and sloppily for the benefit of the taxpayer. However, this is a fallacy. Whilst Benyon's proclamation may be true for certain types of treaties, it is not true for tax treaties at all. Tax treaties are based on the OECD Model Tax Convention, which, despite its issues, is a finely tuned instrument having undergone constant review and 9 iterations over the past 62 years. The terms may be taxed and shall be taxable only are terms of art and cannot be altered by what I consider to be a wishy-washy reference to Benyon. A cursory search, I already mentioned this. The Andhra Pradesh High Court decision in Sanofi is premised on a number of fallacies and should be reviewed with a critical lens whilst advising taxpayers and certainly whilst representing the revenue. I might add one more thing to this. There are many more facets to a treaty. I think the outcome in Sanofi is correct, but we shall leave the reasons that I think it is correct for another discussion. The Andhra Pradesh High Court in Sanofi, sorry, I already read this out, sorry. Maybe the last case for today. I had more cases, but I realize time might not permit me to go through all of them. The next case I should like to address is the highly controversial Assessing Officer versus Nestle SA, 458 ITR 756. In this case, the Honorable Supreme Court had the occasion to interpret a limited most favorable nation clause, which was found in India's tax treaties with Switzerland, the Netherlands, and France. Each of these MFN provisions stated that if India, after the entry into force with the respective treaties, were to agree with a state which is an OECD member state to certain provisions which are more beneficial to taxpayers, then India shall extend those benefits also to residents of those countries. The effect of the MFN clause would come into force at the same time as the entry into force of the more beneficial agreements with the third states. Now, India concluded tax treaties with Slovenia, Lithuania, and Colombia, which had certain provisions for the taxation of dividends, which were more beneficial relative to India's treaties with Switzerland and the Netherlands. However, Slovenia, Lithuania, and Colombia were not OECD members at the time of conclusion of their treaties with India. 4 or 5 years after the conclusion of their tax treaties with India, these countries did become OECD members. The question arose whether the MFN provision would have effect once Slovenia, Lithuania, and Colombia did become OECD members. The MFN provisions, however, stated that they would have effect from the date on which the third country tax treaties came into force. That would be an impossibility, as the third country was not part of the OECD as on that day. Therefore, the Supreme Court's rejection of the application of the MFN treatment insofar as Switzerland and the Netherlands, even though it costs me more money myself, to my mind is flawless The case of Steria, however, which is a technology company which is a resident of France, was different. They were not trying to get the dividends clause interpreted with reference to the Slovenian, Lithuanian, or the Colombian treaty. Steria sought to restrict the scope of the treaty definition of fees for technical services, on the basis that India's treaties with Portugal and the UK, both OECD members, and both of which were concluded after the France-India tax treaty was concluded. The Supreme Court rejected this argument as well, on the ground that the effect of the MFN clause was not notified under the France-India tax treaty by the Indian government. The court held that it was an essential, I'm quoting this, it was an essential requirement of notification under section 90 of the consequences of the trigger or causative event, which cannot be undermined. In this conclusion, the court stated as follows, quote, "A notification under section 90 subsection 1 is necessary and a mandatory condition for a court, authority or tribunal to give effect to a DTAA on any protocol changing its terms or conditions, which has the effect of altering the existing provisions of law." Unquote. Whilst I'm cognizant that law as declared by the Supreme Court is the law of the land under Article 141, we might profit from reading the relevant part of the actual text of section 90 subsection 1 of the Income Tax Act, which addresses notifications. It states, "The central government may enter into an agreement with the government of any country outside India or specified territory outside India, and may, by notification in the official gazette, make provisions as may be necessary for implementing the agreement." Notification is not a legal requirement. Even if we read the word may as shall, the requirement of this notification exists only as may be necessary for implementing the agreement. Where, I ask myself, does the necessity of notifying the agreements come from? Not from a unilateral practice adopted by India as acquiesced implicitly by the other contracting states. This was thought by the Supreme Court to be true, but rather the necessity of notification comes from the procedure laid down in Article 30 of the treaty itself. Once the treaty and the protocol has been notified, and the treaty with the third state has also been notified, there is no more requirement under the law of further notification. The Supreme Court judgment in Nestle is 59 pages long. There are 35 references to section 90, 3 to section 90 subsection 1, and none to section 90 subsection 2, which actually pre-ratifies tax treaties. Perhaps I might, with some trepidation today, and with the most respect to the supremacy of the Supreme Court of India, suggest that that part of the decision on the necessity of notifications might perhaps be per incurium. I do not make this suggestion lightly. Article 141 empowers the Supreme Court to declare the law, not to enact it. That extraordinary power of making law is vested in the Supreme Court only under Article 142, with a view to doing complete justice in the absence of a statute. The Supreme Court's proclamation of the law in Nestle, I'm afraid, does not fall within the scope of Article 142. The 5-judge constitutional bench of the Supreme Court in Dhanvatri versus Commissioner, AIR 1969, Supreme Court 683, has recognized that Article 141 does empower the Supreme Court to alter the law to preserve harmony with the evolving social values. However, that ratio was declared in the context of the unwritten Hindu law towards the interpretation of and not towards the interpretation of a fiscal statute, which, as it is tried to say, must be interpreted strictly. Even generally, as can be gathered from the Supreme Court Bar Association versus Union of India, AIR 1998, Supreme Court 1895, the lawmaking power of the Supreme Court in Article 141 is limited to its role as a problem solver in the nebulous areas of law without ignoring statutory provisions. The case of State versus Ratan Lal Arora, AIR 2004, Supreme Court 2364, is most interesting. In this case, the Supreme Court held that where the Delhi High Court decision was rendered with reference to statutory bars, but by ignoring 3 Supreme Court precedents, was valid. The Supreme Court decisions were rendered without reference to the statutory provisions, and they cannot be said to have any presidential value, being per incurium. These are not my words, these are the words of the Honorable Supreme Court itself. The Supreme Court was magnanimous to acknowledge that those 3 judgments had not followed the statute and therefore were per incurium. Therefore, I restate my most respectful but critical proposition. The Supreme Court's non-reading of Section 90 strictly, in its entirety, in Nestle, deserves at least a close and critical inspection, and that indeed it might be per incurium. I think this should show to us that the evolution of international tax law in India has certainly been quite action-packed, and there have been plenty of judgments, but nonetheless, despite the fact that there are Supreme Court judgments and High Court judgments, not every decision makes it black or white. There might be a whole spectrum of gray and perhaps other colors as well in the middle. I'm very grateful for your attention with this for this highly technical lecture. Thank you.
Thanks, Dhruv. Finally, I'd like to call upon Justice Jain to deliver the lecture.
Respected Justice Srikrishna, respected Mr. Dastur and Mr. Andyarujina, and dear friends. It gives a great pleasure today to be here, and we are really very fortunate that Mr. Dastur, who is considered to be India's topmost tax lawyer, has come and over here today. The topic today on international tax, if you pick up any judgment of either the tribunal, High Court or Supreme Court, you will find that almost 99% of the cases have been argued either by Mr. Dastur or his juniors. So the institution is really obliged to Mr. Dastur for training so many juniors who are today again the top class tax lawyers of our country. And this I say so because every every senior today is so busy, and Mr. Dastur was equally more busy and is busy. But in spite of the same, he used to take the pains to train the juniors. And therefore today, the country has the finest tax lawyers coming from his chamber. I would therefore request the seniors at the bar that in spite of your busy schedule, please train your juniors by taking out some time so that the legacy of the supremacy continues. Now, when we speak of critical evaluation of international tax, we only have direct tax in mind, which is income tax, but that is not so. We have direct tax, which consists of income tax, and we have indirect tax, which consists of GST, customs, excise, and all those laws. So international tax doesn't mean only the direct tax. India enters into various free trade agreements with various bloc of countries or individual countries. In those free trade agreements, there are provisions relating to customs and indirect tax. And therefore, the knowledge of the free trade agreement is equally important when it comes to international tax. The classic example was a Vodafone case, which reached the Supreme Court, and the Supreme Court decided the issue in favor of Vodafone. Thereafter, a retrospective amendment was brought in the statute to recover the tax and nullifying the judicial pronouncement of the Supreme Court. I remember Vodafone invoking the business treaty agreement for recovering that amount from the government of India. So when it comes to tax, whether direct or indirect, we need not focus only on double tax avoidance agreement, but also various commercial agreements or the business agreements or the free trade agreements which India enters into with various countries or bloc of countries. And from there, you will get a lot of clues whether the action of the state is justified or not. And under those free trade agreements, we also have a dispute resolution mechanism, like how we have in the Arbitration Act. First, where we go to the mediation. If mediation fails, then there is an arbitration panel. So there, the assistance of non-tax lawyers would be very important. There is a misnomer that a tax lawyer cannot practice any other law, or a non-tax lawyer cannot practice tax. It's not so. The live example is Justice Srikrishna. Although his area of specialization was labor, but as a judge, he rendered judgments on various topics. And the landmark judgment of Azadi Bachao Andolan was rendered by Justice Srikrishna. And ultimately, the judicial recognition was given by amending the Act in Section 90, where the tax residence certificate has been considered as supreme for giving the benefit of tax treaty. So never be under that impression that a tax lawyer can't do non-tax work or non-tax cannot be a tax lawyer. On the contrary, the knowledge of other laws will help in taxation practice, and the knowledge of tax will help you when you argue the non-tax matters. It will take some time for a non-specialized lawyer to work on a law which is not his comfort zone. But please, whenever you get an opportunity, grab that opportunity. We also have in the international conventions, World Trade Organization, WTO. Now, under the WTO, various trade disputes are resolved. And even the indirect tax, where one country tries to levy customs or GST, contrary to the commitments made to the international convention, are taken for resolution before the WTO panel. And even direct tax, if there is some subsidy or exemption given by the government of a particular country, which really amounts to a tax subsidy, then those issues can also be resolved by going to the WTO. So that is one more arena where the direct tax matters, when it comes to international issues, are resolved by a body called the World Trade Organizations, where also we have an appeal. Of course, like our high courts, the appellate forum of WTO doesn't have many judges. So there is a problem over there. Now, why this international tax issue has become so relevant? Because as my earlier speakers have told, that there is always a tendency of shifting the profits to a country where there is a less tax or no tax. Therefore, the OECD organization came out with BIPS, which is base erosion and profit shifting, and they have come out with 15 action plans. Because globally, about 10% of global tax revenue is lost because of this concept of shifting from high tax countries to low tax countries by the international companies or the MNCs and all, and by, of course, the tax planners. So each country is affected by that, and 10% of the global tax revenue is a big amount. India, out of those 15 action plans, have implemented about 7 to 8 action plans. And the objective of this base erosion profit shifting action plan is to see that each country gets its due share of taxes. And that can happen when all the countries come together and take unified action. Now, classic example of BIPS was the case of an Apple phones. They shifted their profits to a low tax regime country, namely Ireland. And because of the transfer pricing issues, the tax authorities of Ireland gave them a benefit by which Apple had to pay a very minimum tax. Now that issue was carried finally to the European Court of Justice, and ECJ gave a ruling that Ireland tax authorities were not justified in giving the tax benefits to Apple. And that is how the concept of base erosion profit split method was reversed, so that the Ireland gets its tax dues. So this will be a concept, and this is implemented in our country by way of one of the ways, the transfer pricing mechanism. So transfer pricing mechanism works where a foreign company who has a technology sets up a subsidiary in India, they enter into a technological agreement and the Indian subsidiary pays certain compensation for the use of the technology. Now, since there is a relationship between holding and subsidiary which is not at par with the two independent entities, the concept of transfer pricing mechanism gets triggered. There, the Indian tax authorities have been given power to examine whether the payments made by the subsidiary to the holding company is same which would have happened if these two entities would have been independent entities, or what we call it as an arm's length price. So this is one of the way action plan implemented by various countries of OECD to come out of this base erosion profit shifting. In India, we have been quite successful in implementing this. Of course, litigation is there. The Act has also provided for advance pricing mechanism where the foreign entity can go in advance to the Indian revenue authorities for deciding at what price or whether the price at which they are selling their knowledge, technology or goods are at arm's length price. And once that arm's length price or the advance pricing mechanism is agreed between the Indian authorities and the foreign company, then it becomes binding on that, both. The reason being, the country wants less litigation and there is a certainty, because the foreign investors want certainty. They don't want uncertainty to continue, and they are not used to uncertainty in their countries. So advance price mechanism is one of the provision which has been introduced, and we are at the formative stage, but we are making some good progress in that direction. The last provision is general anti-avoidance rules, which we call it in short as a GAR, where a transaction in its form is ignored and the real transaction gets taxed. And the GAR has been so widely worded and it virtually overrides the double tax avoidance agreement entered into by the two countries. So that would be an area which will have a lot of disputes, even if the agreements are found to be genuine, or not genuine in that sense, but they are found to be within the provisions of the law. But if it falls within the definition of or the scheme of GAR under section 95 onwards, then the revenue authorities have been given power to ignore that and tax the real income. So it is a far-fetching, and there is a provision in the GAR provisions itself that it will override the provisions of section 90. Now that will have to be examined as and when the issues come before the courts. Lots have been said by the notification and review of Nestle case. And here again, Nestle case is one of the examples where not only the knowledge of only the tax was relevant before the court, but the issue before the Nestle was more on how the international treaties are to be implemented in the domestic country and has to be taken cognizance of by the domestic court. Starting from gramophone cases and all, although India is a signatory or maybe a signatory to the international treaty under Article 73, 253 of the Constitution, but unless that treaty is made a part of the Act, the domestic court cannot take cognizance of the same. So it doesn't affect the domestic or the citizen unless it is made a part of the act. Therefore, the reason why I am saying is that to cover or to clear the misnomer that a taxation law can't do non-tax and non-tax cannot do tax. This was a case where the knowledge of not only the tax but more of knowledge of international public law and the treaty was relevant for examining or deciding this issue. If you have any questions on international tax, you can ask our panelist, because as a sitting judge, I cannot answer any question and it will not be. And the moment we take the oath, the first thing we are told is that henceforth you have to keep your mouth shut and ears. So certainly, expert panel is there to answer your questions. And this is a field which I feel all of you should take interest, and whenever you get an opportunity, you should grab this. In our courts, we have some of the lawyers from the revenue appearing and arguing these matters, and I should tell with great pride that in spite of they not getting the assistance and they coming from the revenue side or to appear for the revenue, the efforts which they put on, especially on international tax, is so good that it really impresses upon us that such are the budding lawyers who will excel in this field. And the last, I will take this opportunity before I conclude, although it's not so much relevant for the topic today. There is a apprehension, or it is a fact, that Bombay High Court used to be considered as one of the court which will lay down the law on taxation and even on the international tax, because whatever is decided by the Bombay High Court is respected throughout the country. Of course, I should accept that we are lagging behind today in laying down the law on international tax when compared to the other courts. And that is something not a good sign for our High Court, and not a good sign for us, because we learn a lot. So we are also deprived of learning international tax. But the sheer amount of the pressure which the court has and the roster which you see, different types of laws which we have to deal, we have not been able to give sufficient time for the direct and indirect tax matters so that we can lay down the law on international tax. So that I can only say sorry, but we will make our attempt to see that the image of the Bombay High Court has changed. Thank you.
Okay, so we have a little bit of time if members of the audience would like to ask some questions on this topic, please. Just. You need to.
Okay, first of all, I must thank every one of you. You've been so brilliant. Justice Krishna, I must tell you that I still regard Azadi Bachao Andolan as one of the best written tax case, international tax case decision. And I know Mr. Dastur had a lot to do about it, so I'm really grateful that Mr. Dastur is also here. With regard to Nestle case, where the French case has also been tagged along, and you explained this difficulty which is there, since the SLP the review petition has already been declined, do you think, yes, it has been, do you think that there is any possibility for the Supreme Court to entertain, in the name of justice, in the name of international trade, in the name of economic development of the country, to entertain this per incurium issue?
He already had, my mentor, Justice Srikrishna, already has the answer. Maybe he can answer it first and then, okay, Mr. Justice.
It can of course be looked at in another matter. In that matter, it's an end unless you go by curative petition, which is an absurd thing according to me. In another matter, if the issue arises, a larger bench can review this judgment. What is wrong with it? It has happened, no? We go up to 13 judges to decide cases.
Section 11 of the Arbitration Act, just appointment of arbitrator. So from 2 judge, 3 judge, 5 judge, 7, and I landed at 9?
Yeah. So we have bigger
7 judges.
13 judges have also sent in other matters. So you'll have 15.
So always there is a scope for.
In another matter, not in this.
If I may also point out,
Provided you are able to convince the
judges.
Thank you, thank you. Sorry? Maybe, yeah. So it was not intended for this to be an advertisement for me to argue cases, but if you have a brief, I'd be very grateful. No. Sure.
Yeah,
I'll just answer the question.
Yeah, sure.
Okay. I think the issue with the review petitions is that it is only a procedural issue, whether they're going to admit a review petition or not. The admittance or the rejection of a review petition is never made on the basis of the merits. And in a tax case, there has never been a review petition which is sort of adopted, which has been accepted. So it is slightly difficult to do that, to deduce that merely because the review petition has been rejected, that now Nestle is perfect. That is one. Of course, Justice Srikrishna said you could constitute a larger bench, or you could even have an equal number of judges overruling an earlier judgment. Okay.
See, what happened is, even this Azadi Bachao was squarely attacked in the Vodafone judgment. If you remember, Azadi Bachao was 2 judges, Vodafone was 3 judges, and after looking at all that, they have affirmed it. Then that's the way it goes about. It could have been reversed. They appreciated it and said it will be affirmed. Now, who knows, another judge may say, no, it requires to be, he may persuade the Chief Justice to say, constitute a larger bench of 5 judges to reverse Azadi and Vodafone both. That is the fascinating thing about law. There is no full stop anywhere. That is why AI will not really take away our jobs.
Unless it is found to be per incurium, at least a part of it, which is certainly, yeah, okay.
Yeah, I had one question with respect to the Nestle judgment and the MFN clause. So please correct me if I'm wrong, owing to the complexity of international tax law. There is a DTA, for example, between India and Switzerland, and that contains an MFN clause. So India has entered into this treaty with Switzerland, that is the executive has entered into this treaty with Switzerland. So what is the necessity of the executive, that is the central government, releasing a subsequent notification? Because they have already taken a view that the MFN clause applies in so and so manner, and the benefit can be taken under the MFN clause. So the central government, so there must be some exceptional reasons in the MFN clause judgment which says that the benefit has to be taken only by a notification, because the central government need not reiterate its view. So I am senior standing counsel for the income tax department. I must not say that go again, but this is just a discussion. So I'm just putting across my view that once the central government has already taken a view that the benefits can be derived, is it mandatory for the central government to release another notification saying that the benefit can be taken?
The necessity of notifying a treaty, which is, you're right, it has been entered into by the executive. The necessity of notifying that it comes not from section 90, but from article 30 of the treaty itself. When two contracting parties negotiate a treaty and they sign it, they tell each other what process they're going to follow. That is recorded within the framework of Article 30. There is not a single mention of Article 30 in any case law on international tax in India so far. It is that procedure where each country states, this will come into force after I have notified it, and then I will also notify you once I've done the notification process. That's when it becomes the law. There is no such requirement under these particular MFN clauses. There are other treaties that India has concluded which do not have self-executing MFN clauses. Those treaties expressly require that the effect of an MFN clause must be notified. But the MFN clauses that were before the Supreme Court in Nestle did not have these provisions. Now, none of us has a lid on their head that we can open it and see what was in one's mind. I can only defer to the Supreme Court's wisdom in there. Nonetheless, I do think for every person who wants to review critically any judgment of the Supreme Court, it is often told to me that per incurium applies only if there is a larger bench with more judges. But Ratanlal Arora, the 2004 Supreme Court case, is an example where they have said per incurium is not only with respect to judicial precedent, but also the clear language of the law, of the statute.
I'm not concluding that the judgment is per incurium, but I'm just considering that.
I'm suggesting that.
Okay, yeah, you're suggesting that, absolutely. But for another reason altogether, I just want to know on this technical point, like this is a technical point where a view is already taken. Could the view have to be retaken? Or is this discussed in the Nestle judgment on this technical point of the view already taken, which needs to be retaken?
It is discussed.
Is discussed. Okay.
Yeah. The reason why the Nestle judgment comes to its conclusion is its reading of Section 90. Or rather, I think the non-reading of Section 90. Okay. Thank you.
Thank you. That will be the last question for today because we are running short of time. I'd like to now call upon Naushad to deliver the vote of thanks. Naushad.
Justice Jain, Justice Srikrishna, and Dr. Sanghavi, I'd really like, on behalf of all of us and the Bombay Bar Association, to say a very big thank you for, at least personally for me, for introducing this topic to me. And it's a topic which obviously, and even just from the questions which were being asked, it's a complicated topic. It's a topic that has so many nuances and various aspects to it. But you all explained it so lucidly and so simply and gave us those basic foundational structures as what really goes into international taxation. I mean, I in fact just mentioned to Dr. Sanghavi that the fact that international taxation itself is a misnomer, I found really interesting in the sense that there is actually no international tax. It's merely how domestic taxation is applied to an international scenario. So thank you for giving this lecture and for enlightening all of us with your wisdom. And I'd like to thank all of you all also for taking time out on a Saturday, for being here and making sure that the BBA lecture series continues to be a success. So thank you everyone for being here, and please do join us for some snacks which are outside. Thank you everyone.